argument is Kriszandra Clark versus Randall Weekly. It's case number 17CA0090-M. And each side will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Please keep your voice up as these matters are being recorded. The court has read the briefs and are ready to proceed when you are. And let me know if you're going to reserve any time.
Thank you, Your Honor. Thank you, Your Honor. May it please the court. I'm Chong Wan, and I represent Randall Weekly. I would like to reserve 3 minutes.
3 minutes? Very good. Thank you.
The juvenile court in this matter had exclusive original jurisdiction regarding abused, neglect, dependent children, as pursuant to Statute 2151.23a. The juvenile court also had exclusive original jurisdiction to determine the custody of the minor child. The juvenile court also had exclusive original jurisdictions to determine the child support of abused, neglect, dependent child, as long as it wasn't ancillary to some of the other enumerated cases involved in that statute. In this particular case, it did not. Therefore, since the juvenile court had exclusive original jurisdiction in this matter, it had subject matter jurisdiction, and the domestic relation court did not have jurisdiction to issue a child support order in this case. When the administrative child support enforcement agency went to the domestic relations court to have the child support order enforced, the domestic relations court should have advised the department to return back to the juvenile court and advise them that since the juvenile court had jurisdiction in this matter, to return to the juvenile court.
Was child support originally set in the domestic relations court?
No, Judge, Your Honor, it was not. This court never started in the domestic relations court. It started originally in the juvenile court when the maternal grandmother filed a complaint alleging that the parents were unfit, the child was abused and neglect. The juvenile court accepted that complaint, had a hearing on it, and awarded custody to the maternal grandmother, Heidi Clark, and ordered child support and designated the maternal grandmother as the residential parent as well as the legal custodian. The state argues that domestic relations court had jurisdiction and is basing it on RC 230103U, which is a long statute that deals with each different counties in the state of Ohio, and U specifically deals with Medina. And it states that the domestic relations court has jurisdiction in all child support and other cases. However, there's an exception that's carved out in there. It says for some special reason if it's assigned to some other judge. And the special reason is the 2151.23a, 1 and 2 and 11. And that reason says that the juvenile court has exclusive original jurisdiction in abuse and neglect child dependent cases, as well as be able to issue other child support. The state also argues that their contention is that the 2301.03U is more specific than 2151.23A. And under RC 1.51, it does state that specific over general. However, it also states that the court should both statutes should be given effect. And if it's irreconcilable, then the specific overcomes the general. And our contention is that it is reconcilable. As stated in 2301.03, there's an exception carved out. And that exception is the 2151A, as well as other ones that's in the statute. But specifically 2151A gives the original jurisdiction to the juvenile court. And so they are reconcilable.
So you're not arguing husband does not owe child support, you're arguing he owes the child support ordered by the juvenile court?
Yes, Your Honor. We're not saying that Randall, Mr. Weekly, does not owe or does not pay child support. He does owe and pay child support. Our contention the whole entire time has been that the Child Support Enforcement Agency should have went to the juvenile court where this case originated from, instead of going to the domestic relations court. We're not saying that Mr. Weekly shouldn't pay and the child support order should be gone and wiped clean. We are saying that they went to the wrong court and they should have went to the juvenile court. So the order that was issued by the domestic relations court should have been voided and said, return back to the juvenile court, have them enforce it, have them go through the calculation and say how much he needs to pay, what is his arrearages, and
Well, Counsel, you just said that it should have been void. I thought when the trial court exercised its subject matter jurisdiction improperly, it amounts to avoidable injury as opposed to avoided.
that subject matter jurisdiction can be challenged at any time. And so it's not waivable. And since subject matter jurisdiction is not waivable, any court that issues an order when it doesn't have subject matter jurisdiction is void instead of voidable.
And is that why the argument is that he doesn't have to comply with Rule 60B?
Yes, Your Honor. If there's no further question,
Okay, thank you very much for your presentation.
thank you, Your Honor.
Good morning, Your Honors. Once again, may it please the court, Vince Vellucci with Medina County Prosecutor's Office for the state of Ohio, the appellee in this matter. The first argument here has to do with, well, actually both arguments kind of go together here, but a statement that the DR court has no jurisdiction to enforce this child support order. Now, in the reply brief, it was basically stated for the first time that they're not actually challenging the underlying child support order, which was the state's #1 concern, obviously, that this innocent woman and a child not be deprived of a child support order over this jurisdictional squabble, so to speak. That's our #1 priority. And if he's not looking to actually do anything with the order itself, I think this essentially amounts to an academic exercise. I'm not sure there's even a real live controversy here. This may actually be a moot appeal if he's not contesting that. But I think in terms of the actual jurisdictional issue, there was a 2009 dependency neglect abuse case from the juvenile court that awarded custody of this child. Now, the question is, and then you had the CSEA coming in after that with an order going to the domestic relations court. They file an order essentially enforcing that CSEA order. The question is, you have these two conflicting statutes, this 230103U, and you have this 215123, which is the juvenile court statute, the general statute for the whole state of Ohio. Now, the 230103U section applies specifically to the Medina County Domestic Relations Court, whereas, and that's why we say specific versus general, this juvenile statute, that is the statute for all 88 counties. That is the general Ohio provision of the revised code for juvenile courts. That's why we say this is specific over general. That was the trial court's position. I don't think an appellate court has ever held that, but I think from the state of Ohio's position, that is a reasonable position. This court and the Supreme Court of Ohio have repeatedly said that specific applies over general.
So is the opposite true as well? The juvenile court does not have jurisdiction to set any child support in abuse, neglect, or other cases?
I think generally the two courts do have concurrent jurisdiction.
Well, that's why I was asking, who
But-
invoked their authority first? Wouldn't they have the right to adjudicate that issue, whoever invokes their authority first?
Under the jurisdictional priority rule, I agree, if they had concurrent jurisdiction. The question is, do these two specific courts in Medina County have concurrent jurisdiction? And because we have this statute, 230103U, from the state of Ohio's perspective, it's not clear that that's the case. In fact, you have this seminal case of Miller, this old case that says, lays out this jurisdictional priority rule. And it says courts not only that rule applies between courts of concurrent and coextensive jurisdiction. So it's not only concurrent, it's also coextensive. And that term is actually not defined in the revised code, as far as I know. That's defined as having the same limits, boundaries, or scope. But I think if you look at it, DR court and juvenile court, when it comes to child support, do not have the same limits, boundaries, or scope when it comes to their jurisdiction. So I'm not sure. It's a question as to whether in this situation, in Medina County specifically, we have concurrent jurisdiction. And I don't think that's been decided yet. Now our DR court clearly interprets that as we have this statute 230103U, and that means we have exclusive jurisdiction over child support. That is what the DR court is saying. That's what they said in their order below. It wasn't saying that there's concurrent jurisdiction. It was saying that we have exclusive jurisdiction. Juvenile court should not be touching this at all.
Counsel, is there a difference between a court having subject matter jurisdiction and a court exercising its jurisdiction over a particular case?
I think in order to exercise your jurisdiction over a particular case, you need to have subject matter jurisdiction, or you'd be running into problems there with potentially
Well,
having
exclusive jurisdiction as it relates to a particular court that might otherwise have the ability to rule on a particular matter could change depending on the facts of the case, which jurisdiction was invoked first, or what state you're in, that type of thing, right? Is that the exact same thing as saying subject matter jurisdiction?
What county you're in. I mean, in this case, we have a specific statute that says Medina County, all child support matters go to the domestic relations judge. That's what the court is interpreting here. From our perspective, I don't think it's terribly clear on that point. I think you have to look. I think the specific versus general argument comes into play here because they do seem to conflict on the same subject matter, and I think there is subject matter jurisdiction here. But even if there isn't, it sounds like we have a concession and we have a valid support order. I think what would happen though is CSEA would have to start going to the juvenile court now. I don't know that really matters though ultimately for Mr. Weekly's purposes, where that order is necessarily coming from. He still has a CSEA order that he has to abide by. He's not contesting that, which he's just made clear in this reply brief. I don't think it's clear that there's concurrent and coextensive jurisdiction between these two courts in this particular county. I'm not saying the state of Ohio is necessarily taking a firm position one way or another on that. I think it's a question that really hasn't been directly decided. But from our perspective, we just want to make sure this order stays intact. I don't know if we have a preference one way or another in terms of where the order comes from, in terms of the enforcement of the order. Whichever court technically has jurisdiction here, we just want to make sure this order stays in effect. I'm not sure we even have a real controversy here because that, I mean, from our perspective, that is the main concern.
very much.
Thank you.
Thank you, Mayor. Please support. I think there is a case that says that DR court and juvenile court have concurrent jurisdiction. It's a little polling, and it says that both have concurrent jurisdictions. There's other case laws. McDaniel talks about concurrent jurisdictions and how the one case started in the domestic relations court, and then it relinquished that jurisdiction to the juvenile court when it's certified. And so I know the state is arguing that 230103 gives them exclusive jurisdictions, but the statute does not say so. It says you have child support cases, all child support cases, except, and it carves out, so if it's exclusive, it would not put in the exception and carve out an exception. The juvenile court under 215123 says it has exclusive original jurisdiction in this type of case, abuse, neglect, child. It has exclusive original jurisdiction to issue a child support order unless it involves divorce, annulment, separation, or some criminal civil matter, domestic violence case, which this case is not. So therefore, juvenile court has exclusive original jurisdiction stated in the statute. There's no conflict of specific over general because 230103 says, here's this exception when this applies. Right? So the 2151 comes into play, and that is our argument. And we're not saying that the administrative order should be void. We're just saying the domestic relations court's order is void because they did not have subject matter jurisdiction. In this case, the abuse, neglect, child dependent case, to order a child support order. So they should have went back to the juvenile court. Go back to the juvenile court and say, hey, look, we have this case that started in 2009. You confirmed granted custody to Ms. Carr, and the husband or the father of the child is not paying child support as required by the administrative order. Enforce it and issue out a child support order. That's all we're asking, is to void that order from the domestic relations court. And we're just asking here, respectfully asking for this court to reverse the decision of the trial court. Thank you.
The language you rely on it reads, except in cases that for some special reason are assigned to another judge of the Court of Common Pleas.
Yes, Judge.
Has that ever been interpreted? Does that mean that the domestic relations court, for some special reason, assigned a case to another judge of another court?
I don't believe that it's been defined in any case, but it for some special reason, why else would a statute give juvenile courts an exclusive jurisdiction over abuse? So if the juvenile court had no jurisdiction to deal with any of these cases, then it should all just go to the domestic relations court. I mean, it would say that the domestic relations court has jurisdiction over all child support, parenting matters, and anything else. And so why do we need the juvenile court to exercise its jurisdiction on abuse, neglect, dependent child?
I understand, going back to that issue again, you're saying the special reason language refers to the statute, the other statute.
We're saying, yes, this carves out an exception, and as an exception, Judge, there's a statute 215123 which gives exclusive jurisdiction. We're not saying specifically that the legislature said, okay, this special reason means this. We're saying there's a carve-out exception because even in Summit County, under that 230103, it specifically states in there that juvenile court does not have jurisdiction in child support cases. It says except for under exclusive original jurisdiction, which is different than from Medina. That for special reason means that there is an exception, and if for some reason there's an exception, then domestic relations court does not have exclusive original jurisdiction.
Well, in the Ohio Revised Code, and I could not speak to every sentence or every passage in the Ohio Revised Code, but when the exception is another statute, didn't the legislature just usually refer to that other statute?
I believe sometimes it does, and even under the 230103, there are 88 counties. So if you read some of those counties, it says, I believe out of 18 or 19 of those, it says for some special reason. And then it says out of some 4 or 5, it says exclusive original jurisdiction. So they put in different wordings for different counties, and I can't say why the legislator decided to treat each different one with different wordings, but it appears that they carved out an exception for different counties, depending on maybe the makeup of the court, whether it's a large court or a small court.
All right, thank you both for your presentations today. The court will take the matter under advisement and issue a decision once we make our decision. Clerk of courts will mail a copy of the court's decision to each of you, and you can also check as these decisions or opinions are posted on the Supreme Court's website. With that, the court's going to be adjourned until June 14th, when the court will be sitting in Summit County. Thank you again.